My name is Jose Raggio, and I am the President of the Board of Elections for the calendar year 2014 in the Democratic Commission for Queens County. There are the hearings on challenges to the independent nominating petitions for state and local office in November 4th, 2014 general election. I now would ask that each commissioner and staff member present identify him or herself for the record. Starting with my left.
Michael Andino, Republican, lead Bronx County Commissioner.
Simon Schuler, Kings Republican.
Frederick Humane, Manhattan Republican.
Michael Michelle, Queens Republican.
Julie Dent, Local Democrat. Welcome, everyone.
Marie Costello, Richmond Democrat.
Michael Ryan, Executive Director.
John Sandow, Deputy Executive Director.
Pamela Perkins, Administrative Manager.
Nina M. Crispino, Director of Personnel.
Barry Baxter.
Matt Graves, Nominated Record Junior.
Francine Sims Hall, Assistant Administrator.
Betty Ann Cavizio, Brooklyn Deputy Chief.
Kenneth Malden, Council Commissioner. Stephen Jennifer, Council. Steve Richmond, General Counsel. Raphael Spino, Deputy General Counsel.
All right, I want to remind all persons appearing before the commissioners at this hearing must fill the form out of the notice of appearance form, which is available at the front counter. Each person must present a completed form for each specification or matter to our staff as they come up to the podium to speak. I want to remind all commissioners, board staff, attorneys, and members of the public that only one person should speak at any time so that the audio system can accurately record the proceedings. Also, please speak directly into the microphone so that all present can hear the proceedings. I would ask that all present place their cell phones on vibrate or silent ring or turn them off during the course of the proceedings. I want to also advise all present that this committee is required by law to record how each commissioner votes on each matter. In the event that we are not unanimous in our vote on any given matter, I will ask that our council conduct a roll call vote of the commissioners for the record. I now call upon Steve Richmond, General Counsel of the Board, to call the calendar for this hearing.
Thank you, Mr. President. Commissioners, before you, we have two prima facie reports, and then the clerks of King and Chief Clerk and Deputy Chief Clerk of Kings County have prepared reports on the specification of objections. According to your rules, the calendars have been posted on for public inspection on the wall of the hearing room. We'll begin with the legal prima facie calendar. The first item relates to candidate Walter Owachu for his independent nominating petition for member of the Assembly of the 37th Assembly District. The petition filed for the candidate includes sheets without voter signatures as well as sheets of extraneous materials. The other three relate to Mr. Owachu's petition for different offices, independent nominating petitions for Governor, Attorney General, and Controller. Those petitions were filed with the incorrect Board of Elections. Under the election law, those should be filed at the State Board of Elections. Is there any appearances for Mr. Owachu on any of the four legal prima facies?
Before the appearances, I just want to recuse myself from this matter as I am a court examiner on a guardianship matter where he's an interested party.
Commissioner, there's no appearances, so I would ask that you would adopt the prima facie report.
There's a motion to adopt the clerk's report. Is there a second?
Second.
All in favor? Anybody opposed or abstain? I abstain, and the motion carries.
Legal prima facie
Mr. Richmond,
report.
so the petition that was filed had either blank pages or pages, because we've had issues with Mr. Owachu in the
It
past.
was in the same form that he filed designated petition this year, which included petition pages without the voter signatures, some with typed in names and addresses, but absolutely no signatures. In addition, he included in the petitions copies of various, what appears to be legal documents in unrelated proceedings, just to create sufficient bulk.
So in the past, we have referred these to perhaps appropriate authorities because it's a filing that has no real material basis to it and would almost constitute a fraudulent filing.
Commissioners, we have the New York County District Attorney's Office have in both last year and the prior year brought him in for discussion. I have been advised by the District Attorney's Office that they felt that there wasn't a person who would have the capacity to be charged with a violation and declined to pursue it.
So they didn't have sufficient mens rea, is that what you're
Yes,
saying?
that's what they believe, that he did not have the sufficient mens rea to be subject of a criminal proceeding, although they were aware that it was prima facie evidence which normally would have gone forward, but they had brought him in both in 2012 and 2013 for investigatory interviews.
So I think if we did in 2012, they said no, 2013, they said no. We're not gonna send, I believe we should send it, just so they say no, I don't,
That's fine.
because maybe now they'll say there's enough. I don't know.
Or maybe there would be an alternative remedy that they could come up with, like an injunction enjoining him
Right.
from phony filing with this board, something along those lines.
Commissioner, I don't know if you would want to authorize a referral to the New York County District Attorney's Office. We will prepare the necessary correspondence and transmit the documents.
You wanna make the motion?
I make the motion to refer this to the DA's office.
Is there a second?
Second.
All in favor? Anybody opposed or abstain? I'll abstain.
Commissioners,
Motion carries.
we'll get the letter out within the next couple of days, and we will make a phone inquiry first to let them know it's coming.
Thank you.
The next item is the candidate records unit prima facie report, and Mr. Graves will be calling that calendar.
Good afternoon, Commissioners. Our first item on the CRU prima facie report is regarding the Libertarian candidacy of Angel Molina in the 84th Assembly District. Petition there appears to have insufficient signatures.
This is the weight rule?
Yes. We have some others on that same rule. In the 68th Assembly in New York County, Tamika Mapp as well, insufficient signatures. David B. Casavas for the 73rd Assembly District for Member of Assembly, Libertarian. And as we were just discussing, Mr. Iwachu's petition also appears to be insufficient for any of the offices that he submitted. And in addition to all the insufficient signatures matters, we have one other matter for David Paul Garland in the 76th Assembly District, a member of Assembly, where he had no acceptance filed.
And notice was given to this candidate, because he's run on this party in the past.
Yes, notice was given to all candidates.
Are there any appearances on the candidate records unit prima facie calendar?
I would ask that Garland be put on second call, and I would move the rest of it.
Is there a second? All in favor? Anybody opposed or abstain? I'll abstain as to the Iwachu. Motion carries. And then the second call.
Prima facie report for the CRU report for the 84th Assembly District, 68th Assembly District, 73rd Assembly District, and 37th are adopted. The 76th AD matter is put to second call. Commissioners, we now have 3 specifications of objection to independent nominating petitions that were filed with the board. The clerks of the Brooklyn office of the board have prepared the reports. They are in the folder marked Kings. And we'll call them if there are any appearances with the candidates and their representatives, objectors, please step forward. First is spec number 1 in the Superstorm Sandy Relief Independent Body. It's the objections by Jonathan Yedden and the petition of Stamatis Lilakakis for member of the State Assembly in the 46th Assembly District. Clerk's report, 392 signatures submitted, 216 of them invalid, 176 valid, 1,107 signatures are required to qualify. Appearances, please.
Jonathan Yedden, 533 4th Street, Brooklyn, New York.
11209. I am the objector. I just want to thank the Brooklyn Board employees for working the spec, and I just want the commissioners to adopt the clerk's report.
Any other appearances? Is there a motion to adopt the clerk's report? Is there a second? Second. All in favor? Anybody abstain or opposed? The motion carries.
Clerk's report is adopted unanimously. The candidate will not appear on the ballot. Commissioners, we're going to call spec numbers 2 and 3 together. The matter for the Housing and Jobs Independent Body It's the objections by Inspect 2, Margot Getz, and Inspect 3, Helen Koenig, both to the petition of Carl Caller for member of the New York State Assembly in the 48th Assembly District. Both clerks' reports show the following: 2,102 signatures submitted. Clerks find 1,074 invalid, leaving 1,028 valid. 861 signatures are required to qualify in this Assembly District. Appearances.
On behalf of the candidate Carl Caller, I am Ezra Glazer of Conde and Glazer LLP, 291 Broadway, 17th floor, New York, New York, 10007. Both of my notices are right here.
Any other appearances? Is there anything you want to add?
Well, I just, I didn't look. Is there actually proof of service of the spec? For both specs, that is.
Commissioners, we do have a certified mail receipt clearly labeled for objection 2 and 3 and attached to a copy of the first page of the spec. Timely filed.
And all the relevant information?
With all the relevant information and in accordance with our rules that they not only indicated which objection number it is on the proof of service, they also attached it to the first page of the spec.
So the answer is yes.
Okay, so I'm just going to ask that the board move to clerk's report.
Okay. Is there a motion to adopt the clerk's report? Is there a second? All in favor? Anybody opposed or abstaining? Motion carries.
Clerk's reports for number 2 and 3 are adopted. The candidate will appear on the ballot. Thank you, Commissioners. Commissioners, that concludes the hearings on independent nominating petitions and related matters for the November general election.
I'd like to thank the Brooklyn staff for their work on this.
Thank you very much.
This concludes the hearing, right?
That concludes the hearings. I have the next 2 items.
All right, so we're going to call the regular scheduled meeting to order. And I have the commissioner, I'm Jose Araujo, the president, and I have the commissioners starting on my left introduce themselves.
Frederick Humane, Manhattan Republican.
Michael Michelle, Queens Republican.
Michael Ryan, Executive Director.
John Santo, Deputy, I'm sorry.
Pamela Perkins, Administrative Manager.
John Santo, Deputy Executive Director.
Dina Espino, Director of Personnel.
Kenneth Bowman, Council Commissioner. Stephen Dankberg, Council.
Steve Richmond, General Counsel.
Raphael Spino, Deputy General Counsel.
Do any of the commissioners have anything to add to the agenda? I know Bronx has a matter. I'm going to add for executive session, personnel.
And Commissioners, 2 things. We have a challenge to a vote of the registration to be done in public session. We also request, we have for the cure to the notice of non-compliance that the committee proposed, Commissioner Dent and Commissioner Humane sent out last week, so I did a cover sheet review committee immediately after such a item.
I'll do it since I was on.
Okay. Can I have any Democratic volunteer? Okay. I'm going to designate Commissioner Dent on the Democratic side and Commissioner Michelle's designating Commissioner Humane to do the cover sheet immediately after this regular scheduled meeting. And then we'll hear the challenge after we're done with our agenda.
And in addition, there is a executive office, executive session with personnel matters.
Commissioners,
Mr. Richmond?
my second item. Each year, the board has delegated its authority as the Board of Canvassers to provisionally certify the results of the September primary election only for delegates and alternates to the judicial conventions of the parties with ballot status for the respective judicial districts to the respective Borough Commissioners Committee to enable both the board and the political parties to meet their statutory obligations as set forth below. The reason for this authorization is another conflict in the election law. Section 6-158-5 directs that the conventions be convened in 2014 between September 16th and September 22nd. Section 9-200 directs the city board to compile the roll of the convention and transmit it to the chairman or the secretary of the committee which is holding the convention and how that roll should be prepared. In addition, Section 9-200 says the first thing was supposed to canvass after on the returns, receipt of the returns to the delegates and alternates, and to complete such as soon as possible. But the election law also requires us to conduct the canvass of absentee, military, and special ballots no earlier than the 8th day, after the 7th day to receive ballots, which is the day after the first day to hold conventions. And we have 15 days normally to complete the recanvass for the entire primary election. Given the fact that the conventions have to begin before even we begin counting absentee ballots, in the past you have delegated your authority to the borough commissioners to provisionally certify the results of the delegates and alternates based on the election night returns and the recanvass of the election of the poll site ballots. Again, if there's a very close contest where it's uncertain as to one or two candidates get elected, we don't certify those. The beauty of the system is we will be able to certify alternates, and if the delegates aren't certified, the alternates can. We've been doing this, going back to the legal machine for at least the last 10 years, and asking to authorize it since the first convention, I believe, is scheduled for next Tuesday.
And just so you know, Queens is designated for September 18th.
Okay, so they have a couple of days. I believe Manhattan Democrats are meeting on next Tuesday.
All right, so I would move the recommendation.
I'll second that. All in favor? Anybody opposed or abstain? The motion carries.
Okay, and Commissioner Stoll, I believe the CIU will be reaching out to you together with your borough staff as soon as the initial canvass of the voting machine, poll site ballots are done, so that we could meet that. And also, Commissioners, if you're aware of when the other parties need their rolls, to let us know so we can be prepared. It'll be helpful because we want to cooperate and meet our obligations under the election laws.
Thank you.
Commissioner, my last item is an application by the New York State Green Party to invalidate the alleged fraudulent certificate of authorization filed with this board. By letter dated August 29th and received on Tuesday by this board, the statewide elected officers of the Green Party advised the city board that a candidate for member of the Assembly in the 83rd Assembly District in the Bronx, who is not enrolled in the Green Party, did not receive the authorization from the appropriate party committee to appear as a candidate for public office. According to the information submitted and our initial review, the statewide duly adopted bylaws of the Green Party provide that certificates of authorization, or Wilson Pakula certificates, are to be issued by the statewide executive committee, except for what they call affiliated counties, meaning constituted county committees. They also advise that they advise all of the boards of elections in 2013, which such affiliated counties were present, were constituted and affiliated. Bronx County wasn't. And they also claim that there's a reference in this invalid certificate to bylaws of the Bronx County Green Party. A check of our record shows that no such document was filed with the board. But this is a serious allegation. It appears, at least if it's founded, that a fraud was perpetrated on this board. What I am recommending in order to provide both due process for all and as well to meet our obligations to the ballot is your permission to schedule this matter for a hearing for Tuesday, September 16th at 1:30. That's our next meeting. Notice will be given both to the officers of the Green Party State Committee and to the candidate at this point, Trevor Archer, asking him to come in and explain.
What would be the parameters of this hearing?
I think to see if they give the candidate an opportunity to provide contrary evidence that the information provided by the state committee and through the state board, that bylaws are not correct. I think that's the only point, Commissioner. I mean, I would think upon receipt of notice, if their allegations appear to be true, we may not have an appearance for the candidate.
Yeah, but do we have jurisdiction to sort of make a determination of fraud?
Well, I think again, normally, I guess, there's two options. One, there would be someone who would file an objection. According to the state party, Green Party, they didn't know that anybody was filing in the Bronx without their authorization, because they were issuing the certificates of authorization for those approved candidates. It's only when they received the copy of the candidate list from the board that they saw this candidate who was unauthorized. I think if we had an objection, Commissioners, without a question, we can act on the documents on file with us. Each party is required to file copies of their rules with the state board, which is a public document, a matter of record, and the rules under the election law have the force of law unless they're contrary to the election law. And the law provides that certificates of authorization is to be issued by the appropriate party committee, either for that political subdivision or as the rules the party would provide. State party rules trump any local rules too. So normally we would have jurisdiction, the question is of timing now. And what other remedy is there available to prevent, if this is a fraud, from being now, after being perpetrated on us, being presented to the voters.
Well, I think traditionally, as Mr. Richard pointed out, there is a time in which an objection should have been made, but it's kind of an issue the commissioners have grappled with before. Now that it's before you and you're aware of a potential fraud or someone who shouldn't really be on the ballot, can you on your own, without an objection, take it up and review the allegations to make it correct what wrong was done?
I think we've always taken the position that once we are apprised, when we put on notice, we always act. But the question is, how far can we act? That's my question.
And I think Commissioner, therefore, giving them, everybody the opportunity to be heard, I think we preserve due process. I can only cite to the Appellate Division 3rd Department decision, the Sam Sloan case, where they allege that the state board abused its authority by acting on, if you will, on a weight test type of issue. The Appellate Division concluded that the state board has inherent authority to prevent the perpetration of fraud on the public with a clearly insufficient petition. Court of Appeals declined to lead to appeal, so I think that's the current case law. I think by analogy, I think you could argue the same thing here. If now we've been brought to our attention that there's on its face a fraud, we'll give an opportunity to be heard, and I think then you'd have the authority to act. And I think Mr. Archer would then, if he thinks we don't have the authority to act, would be free to commence a proceeding challenging it and explaining to a court why he filed this document.
All right,
So right now, I'm looking for the alternate to set down for a hearing. It doesn't prejudice, or we judge the hearing, you still have the right to make your own judgment on the 16th.
and you'll notify all parties, including the state committee?
I would notify the officers of the state committee who filed the letter addressed to you, as well as the candidate.
Does anyone have any further questions? All right, I'd move that we set up this notice and set this up for next Tuesday. Is it
From
next,
Tuesday,
a week from Tuesday? A week from Tuesday. All right, all in favor? Anybody opposed or abstain? All right, the motion carries.
Thank you, Commissioners.
The minutes. The question I have with respect to the minutes is, we have the minutes from August 26th, which consisted of Fred Remain and Julie Dent. How are we going to adopt those minutes? If habit is that the commissioners who were not present would abstain.
If you want to adopt them as a committee, or, I know we do it, I think Commissioner Dent and Commissioner Remain will adopt it, and we'll list it on the agenda as a committee minutes.
Okay. So is there a motion to adopt the minutes with respect to August 19th? Has everybody had an opportunity to review them? Yes?
Second.
We'll second it. Motion's been made, it's been seconded. All in favor? Anybody opposed or abstain? I'll abstain because I wasn't present. And the motion carries. I would move that we convert the minutes from August 26th to a committee minutes. And is there a motion to committee report?
I would, as the Royal High Poobah of that committee, I would move that we adopt the minutes as a committee report.
Is there a second? All in favor? Anybody opposed or abstain? All right, the motion carries. Michael Ryan.
Yes, Commissioners, on August 20th, I forwarded an email to the Commissioners seeking input with respect to changes to the procedures that were necessitated by several things, not the least of which was decisions that the Commissioners had made over the course of time. In any event, this is a very cumbersome process. It went on over a course of several months with interaction between the legal department, most notably, and EBS, the departments. And they have come back now with certain proposed changes, which I believe there is substantial consensus on, although there might be one that there isn't. But in any event, the first item that we're looking to Commissioner approval on is, in our canvas procedure section 4, that is basically the spot where we have it all laid out how canvas procedures are supposed to work. Over the course of time, as different changes were made, that became several documents, not including the 2010 post-election activities procedures, the BMD ballot canvassing procedures, the central ballot scanning system audit procedures, and the recanvass of mechanical lever voting machines. Now, we're leaving that one in there right now because we haven't had a change in the law yet, although we're not anticipating that the lever machines will be used again, but just in case they are, that procedure needs to stay in place. So the first item that we're asking is just for permission to consolidate all of those disparate documents into one Canvas Procedures Section 4, so that it will essentially establish a one-stop shopping reference point for staff, so when they're going through the Canvas procedures, they don't have to continue to look in disparate documents. That's first one. Second one is allowing the utilization of the electronic write-in filter feature that will allow for the workers, when they're going through the post-election process, not to have to look at every ballot, that they'll be able to use the filter feature and only look at those ballots that potentially have a write-in. And the third one is regarding audits to be conducted on the DS-200s, not on an ED level basis, and that is simply being done to conform with the results tapes procedures that were previously adopted. And number 4 is regarding the counting of ballots where PMDs are inoperable. And the 5th thing that we're asking for, which is a change that I don't know that there's complete consensus on, but we're looking to change the threshold of the manual recanvass in a contest where more than 1 million votes are cast, from 0.5% to 0.2%, and I believe there's consensus on that among staff. And the other 2 issues where there might not be some consensus, but certainly I'm in favor of the adoption. Manual recanvass, a manual canvass under that threshold standard for public officers only. In other words, folks that are elected officials. That would not apply to party positions of any kind. The reason that we're making that recommendation to the commissioners is, despite this interim procedure, it wouldn't affect the interim procedure that was just voted on, but last year, in the primary election, we, in fact, conducted a manual recanvass for alternates to a judicial nominating convention after the judicial nominating convention was already over. Given the scheduling difficulties provided by law that was previously outlined on another matter, we're essentially doing a manual recanvass for really no reason. The judicial nominating convention is over. Whatever judges were nominated were nominated. The duties of the individuals that were party to the judicial nominating convention have been fulfilled, but yet because of our own procedures, we're doing a manual recanvass on things that have ultimately zero net effect. And I don't think that's necessarily a good utilization of board resources. The other thing is authorize a limitation on the manual recanvass to only those contests that occur wholly within the city of New York. We have some jurisdictions or subdivisions that extend from one county to another. If we adhere to our rules within our county and the other counties are doing something different, then we're treating candidates within the same district differently. And it really doesn't make sense. I don't think that we should be in a position as a board of trying to impose our rules on other jurisdictions. Now, that doesn't apply necessarily. I mean, if we're doing it to jurisdictions wholly within the city of New York, well then, that certainly is our purview.
Yeah, hi, just Couple of questions. If the issue regarding manual canvassing comes up in the context of judicial delegates, then maybe we ought to say we shouldn't do it for judicial delegates. But at least in my county, for the Republican Party, we very rarely have races for district leader. But there are other party positions that would possibly be contested and might have longer lasting effect than at least 2 years rather than judicial elections. So maybe we would just say we won't do it for judicial elections, but maybe for district leader or some other party positions that maybe we would consider doing that. That's one, you know, and so if we have a problem, and I understand the problem, particularly alternate delegates to a judicial convention, let's just deal with it on, you know, on the smaller level rather than the larger level.
That would be helpful as well.
And on the, you know, the recounts that are on the sort of the in and out of districts, I understand that, I mean, we have our procedures, and we think our procedures theoretically make sense, otherwise, why would we be doing them? So why shouldn't we sort of make them conform to us rather than us conform to them where they have lesser scrutiny? One of the things that people haven't criticized us for is our re-canvass procedures, and that they're pretty good, people think. Even some of the good government groups have said that our re-canvass procedures are pretty good. I'm not sure, you know, just because people in the rest of the state don't do things the way we do, it means that we shouldn't do them what we consider the right way. I mean, for instance, they don't have public hearings on ballot challenges. And instead, we have the luxury of hearing these wonderful legal arguments for 3 days from election counsel. So we do things a little differently, and maybe our way is better, I don't know.
Well, I just think it's difficult to assess what the cutoff is. When something crosses a jurisdiction, what if it really isn't a matter of contest within the votes that we have to tabulate, but because of the votes that are received across the line, it drives it into this cutoff? Why would we be then manually recanvassing our votes if it's really not a question of clarity for, I mean, if it's a question of no lack of clarity for us? I mean, you know.
I agree with you, but maybe if you give an example, it'll be clearer.
Two things. One, in the 3rd District Republican primary, we found out that the 3 counties did things completely different. For example, in Nassau County, as soon as an order to show cause is signed, they stopped everything. They didn't even open up the ballot bringings, which is not our procedures.
But that's not the same thing.
No, it's the same contest. The other part is that our own rule only applies to within the votes cast within the city of New York. So that if the margin of victory in, let's say, the 3rd Congressional District Republicans was less than the 1/8 of 1% in that portion of Queens, then we would conduct the count. If the margin overall of the district wouldn't, because you are only, commissioners are only allowed to certify only those votes cast within the city.
But what if it doesn't affect the overall outcome of the contest, then why are we doing it, is the question. That's really where, I think that's the meat of this
The
argument.
reason was is that there was always, at least the rationale for this rule was, that when we got to having machines count votes, when it got to that level, and I think that's why we changed, recommended the difference of percentages, when it's over 1 million votes, because it needed more to change it than below it, and we came up with a number to do it so that we have an accurate count. So that when, for example, in the 3rd District, we certified on schedule the Republican primary, we were done. So by the time we went back to the second court date, we were thrown out of the case because we were finished our function.
I think in the very least, the policy needs some clarification. Although it was instituted before I was here, I believe it was put into effect where there's a very close race, and people are concerned about the intent of the voter being determined from the ballots themselves, we want to make sure we got it right and look at those ballots. But my question is this, so the problem that this presents is, if it's close within New York City, and yet a segment out of New York City makes it a blowout, so
Well,
to speak,
what I'm
not close
trying to
enough,
say is,
what's the point in
what
doing
if,
this manual?
what if you have
Has
a
no
candidate that comes from Suffolk County, let's say, and that's his stronghold. That candidate gets 100,000 votes in Suffolk County. Crosses the line to Nassau and into a small part of Queens, which is New Hyde Park. And I'm just using, and I'm not sure. So now, that candidate takes all of Nassau County, all of Suffolk County, but in Queens County, it comes within our margin. Now, it's a blowout. The one guy's winning by 70,000 votes. But because ours fell in within this 1% or something like that, we have to now recount it. Right? We would have to recount it, and then we would have to take overtime and all of that stuff just to do this thing, and then the newspapers or everybody else will turn around and say, the Board of Elections is now spending money and everything on a race that we all know is over. Is that in plain English? I mean,
Yes.
Oh, okay. Because sometimes I
That
get
is
lost.
specifically what we were trying to address by limiting the words to wholly within the city of New York.
I know, but I have to do it in a small,
I got you.
simple thing.
But I think that this is overarching, where, you know, there can be some sort of caveat that makes that distinction.
Right, well, that's what I'm saying is, but I understand that distinction, and I understand why the rule is there, but something has to be.
No one wants to waste our time.
Right.
And
Well, the whole purpose of adopting the rule was that it's an objective standard.
Is-
So when
is it a-
specific facts came up, it didn't influence what we were.
Is it a state law, is it a rule, or is it our policy? So could we do something that when there is across county lines or something, lawyers come up with, across county lines, if, I don't know, some formula to come up with another.
For the contest. It should be based on the total results of the contest, including the Adams County votes, not just within the city.
The commissioners, for example, in the Nassau, the third race.
But they stopped it.
We couldn't be certifying them because you wouldn't know what the
But
total
that's
was.
it.
Because in that case, the difference between the winning and losing votes was like 8 votes. But we didn't even know because Nassau couldn't even give us preliminary numbers at the first.
But then we could come back to us and we could decide on an individual basis. I don't know, that's a
With
one
nothing
case.
to do with on a
That's
specific-
not a
so
norm.
You didn't have specific personalities of candidates and other things in there. The whole idea was to set up a policy in advance that was hard.
I think there's a way around, somehow of accomplishing both. I don't know, I think because this rule here, I mean, you could have somebody not, like I say, plain English to me, you won by 100,000 votes, and in New York, you got 100 votes, and the other opponent got 99, or whatever, yeah, I'm there. We're gonna sit down and count. Don't make sense. I don't know, that's my.
I agree with you. I think we need to.
You gotta come back with some solution to accomplish both of the things we want.
how about this? Supposing half or more of the district lies within the city of New York.
Yeah, defined as what? Registered voters?
Registered voters.
Votes cast.
No, registered voters. If more than half of the registered voters in that district live within the city, then we do it sort of our way. That way, it's primarily in the city. And if it's less than that, in your case, in the third, where the district was primarily outside of the city, then we wouldn't do it. How's that for a compromise?
Unfortunately, we still could be manually recounting a vast amount of votes in a contest that wasn't even close.
Maybe I missed something. Why can't we do it based on contest per contest?
But we should have set rules before the game is in play, so that it's the same set of procedures every single time, and nobody can say that anyone's treating a particular contest or candidate differently. But again, it doesn't mean we can't come up with some sort of set policies and procedures that is more rationally related to the results of the contest, and where it would actually make a difference.
Commissioner May, the question is.
I'm just-
would
I'm thinking out
the standard
loud,
be
trying
that
to-
if more than 50% of the district is in the city, and then the votes in the city fall within the guidance, or we would be looking to try to add in all the other votes? Because again, part of the problem will be is we may not have access to those other votes.
Yeah, you can't have the other vote, you just have to be able to.
No, it would be,
And
it
if
would
the
be,
standard will be if more than 50% of the district is in the city, then the standard of the city rule would apply.
Does John Notice have?
I just wanted to interject one thing with all due respect to Mr. Richmond. The way the procedures are written now, it says the margin of victory,
Right.
which would mean all the votes for the contest, not just the portion in the city. His interpretation is that just means the portion in the city, but we did not write the margin of victory within the city of New York. It just says the margin of victory for the contest is within 0.5% or 10 votes. So
The only
I would leave
contest-
that in.
The only contest the commission is certifying though is New York.
I would think it'd be up to the commissioners then to determine what that means as far as, does it mean just the piece in the city or the entire contest? Because it doesn't specifically say it as far as the procedures work. That's why we're trying to narrow it to
Right, but
only
can I
within.
add- But it's not a state law, it is a policy
It's a
we got,
policy set
so we
by
can
the-
interpret what you're saying any way we want.
Correct. I just wanted to show
I
that
just have to,
there's an
put it
alternate
in-
view than Richmond's on, that it's only
let's
the
interpret it
Toastmasters.
now, what we want.
That's what I'm saying, at the very least, there needs to be some clarification.
It has to be consistent. It can change from interpretation from election to election. I think contest is a contest. It's the race.
Says commissioners, you don't have jurisdiction over the whole contest.
We just count the votes, we just get what
We
the
don't
votes
just
are.
certify, the whole purpose is to provide an accurate certification for the votes cast within the city of New York.
But it would have said
But
that.
it's based
Then it
on-
would have
Well,
said
that was,
that, and
that's
it
when the only
doesn't say
jurisdiction the
that.
city board, that was the city board policy only applies to the city of New York.
There's-
We can't impose this on that.
there's another issue too. I'm just, again, I hadn't thought this through, but there's an equal protection argument as well. How you would treat certain ballots in part of the district and other ballots not in that part of the district. So that would be a strong argument for doing all of the review post-election in the same method for the same district. There's another level of that. Why in a mixed district do you do it one way and in a city complete district you do it another way? That's also an equal protection argument.
Except though that I think that when you get to that level, it's hard to make that argument tangentially against, it would be one thing if you were treating two candidates within the same district running against each other differently. But if you're gonna now take an equal protection clause argument and try to impose that on another entity, I don't think it works. Because this fundamental premise of equal protection is treating likes alike. Now, the question is, and I know we talk about these definitions, what's the definition of the word is, what is the definition of a like? Is somebody like someone because they're both running for assembly? Well, maybe that's differentiated because this assembly district crosses county lines.
Well, you also have the issue in Erie County is certainly different than anything in the city.
But they all pay
Exactly.
taxes,
You
so
know,
we,
So, I mean, I
I
don't know that it's that cut and dry, but I do know that the policy as presently constituted presents a problem because of what we've discussed here, what Mr. Nordis has added in. It says margin of victory. Well, what's the margin of victory? We're only paying attention to the margin of victory in the city of New York, and we're not paying attention to the margin of victory elsewhere? Well, that's not English, right? That's not how it reads. If the commissioner's intent or the policy intent was to clearly assert that it only applied to the city of New York, we're lawyers, most of us. And I think that the legal counsel has to, view it like a lawyer. It's got to say what it says and say what it means, right? So it says margin of victory, which means, to the average person reading that, means the margin of victory, which is the overall
And
subdivision.
actually, I think we thought this was something that might have been thought of at the time that policy was done, because just of this, and what happens when we get old, we forget things, but I think that was part of the analysis.
Getting a lot of votes within the city of New York in a run-over district is not victory. Victory is getting more votes than another candidate.
Right, that's what we're trying to say. So if we happen to have a razor-thin margin on the votes within the city of New York, but yet it's a landslide in the crossover piece of the district. Why are we recounting all of those votes? The idea is to make sure that the winner wins, right? And count every vote within the process. And you want to make sure that there's absolutely no mistakes made when it's, especially in those circumstances where it's going to affect outcome. But if that were going to be the case, then we should just manually recount every election under all circumstances. If the electronic aspect of this system doesn't count for anything, then why don't we just stop it and count it all by paper and go back to the way it used to be, 100 years ago? I mean, it doesn't make any sense to me, but that's...
But it's a recommendation of the executive management and the supervisor of facility department that we should change it.
That's my recommendation. I put these bullet points down in an email to the commissioners because I think they all make sense.
Yes?
Yeah, I think, well, that's what I was gonna say. I think that what we should do is interpret what our actual regulation means to say, really what we mean is the margin of victory for the race, which is really what it says. And that we could then look to see if it's a landslide, and if it is, not waste everybody's time. And that would be the policy of the board, and I think that would be, so my view, which Commissioner Shamoon just echoed, is that we leave it alone and we just clarify our interpretation to mean that margin of victory means what it says. We look at the whole election and determine if it's very close, and if it is very close, then we'll count ours by hand, and if it isn't, then we won't.
Right. Well, and the reason that this came up was clearly there was one school of thought that said it was only the margin of victory within the city of New York.
Now you just got
Right,
clear cut.
and then there was another school of thought which was, that doesn't make any sense for all the reasons that were splayed out. So if we've now clarified that, then,
So I would move that we clarify it.
right.
You have the original language?
Yes, I think John Norris quoted the original language, which was
Somebody read it.
John, do you have the original language? And
I
Mike?
have to get it.
But in any event, it said
It says margin
margin of victory.
of victory. The
Which
race, margin of victory, right, so the margin of victory, so,
Was less than 1/2 of 1% of what 10
okay,
votes was
so
less.
the idea is that we had one group saying that the margin of victory, right, within the city of New York. Then we had another group that turned around and says the race is for the entire race. So now our interpretation is the race for the entire.
Right.
Instead of the old interpretation, or the one there, was just within the city of New York. Okay.
Right.
All right, I just
In which
wanna
case, I
make
don't
sure.
think that it requires a language change, and as long as everybody understands it's the margin.
So
No,
the minutes should
there has to be
reflect, the
some
minutes should
notification.
reflect our interpretation
Right,
of
there has to be
that.
some notification to the public.
In the policy, defined that way.
Right, and that should be on the website, so make sure.
All the,
and-
eventually, Commissioner, the policies and procedures, the canvas is on the website now, all of them are there.
Right, but once these are all
What
adopted
this is,
today, he's
right,
saying-
this is there, and then, sometimes you could put it in a little
Put in a footnote.
English, a footnote that this policy means the entire race.
And it needs to state next to it revision.
Right, revision, this means the entire race, not like previous.
And in terms of equal protection, I don't think this would be a strict scrutiny analysis. I think as long as there's a reasonable basis for the agency to make this determination, we would be on safe ground. And statewide, there's various rules for various counties, the times people are allowed to vote, different in the city of New York and other areas for primaries, even when it's a statewide race, so.
So is the, on the Metzger, is the decision that New York will be, or the portion that's in New York City will be recounted regardless of the differential within New York City, so long as the overall race, the
Was
overall.
it that 1% or what?
Was it 1/2?
One half, right.
So even if New York City, just throwing out a number, is 10,000, 4,000, a 9,000 differential, it gets recounted
Yes,
So that's
because
the
we look
intent.
at the
Based on
entire.
The entire race, you're looking.
Regardless of.
Regardless of whatever they
what
do,
happens. Okay.
if it falls in our guidelines across county lines, it's gonna be
Right,
reformed.
clarify the intent,
If
okay.
it falls in within the
The entire race.
The entire race
Not
falls
just New York City.
No,
Right,
the
that's
entire
why-
race, Nassau, Suffolk, and Queens.
But I will say that we've now
Right,
just,
I'm showing the alternative, right. Ours is a big discrepancy. The other,
Right.
that's fine, I just wanted to
but
ask, make sure this.
But Mr. Moltner, thank you, Mr. Moltner. He just raised again why we limited it and why our recommendation was wholly within the city of New York. Because he's right. The reverse is also true. You could have a razor-thin margin, and the portion of votes that we need to count.
The opposite way.
It's the opposite, and our margin of victory is, our margin of
Yeah.
disparity between the votes is so wide,
I was just asking a question.
you know,
Yes.
I mean,
Yeah, but that's, but if the election is so close, then even though it's a 10-1 in the city, you may be able to pick up the 12 votes that you need to win the race.
That is true.
And so,
Yes.
I think that.
that's not something I considered, but you're right, Commissioner. That part is true.
Yes,
We
Mr.
still
Morris.
want the language of the standard?
Yes.
All right. It states, if the margin of victory in any particular contest is less than 10 votes or 0.5% of the total votes cast, there shall be a manual recanvass of each paper ballot for that contest.
So that's.
So we could put a footnote and revise, right? Entire race.
Changing the entire procedures, now you're gonna put the new language in.
Okay.
I don't think it needs new language. It's
It doesn't
exactly
need-
what it's the interpretation. You were interpreting it one way, and they were interpreting it another. It says entire
Two things, it
race.
has to be, but again, how do you count ballots outside the city of New York? That's the question, and I think that's what you have to make clear, because for example, are you, the only time we do a manual recanvass is after we finish the manual, the recanvass the machines, and the canvass of paper ballots. So for example, and then we hold off on certification if it falls within that margin. In this case, take the aggregate, we would have not been able to make that determination vis-a-vis the third district in Republican primary, because NASA hadn't even counted until after the court finished. The margin of victory in the end ended up at, what, 18 votes or 20 some odd votes, which may have then fell within it. I think the question is,
Wouldn't
what's
that
the
just mean
timing?
we have to recertify?
What?
If we just did it on our own, and then we found out later on that the numbers changed from the other counties?
But I think also it depends on what line of demarcation do you want to draw. We're doing our process. If during the period of time that we're doing our process, the information is such that we have reasonable cause to believe that the margin of victory is within the standard that we set, we don't have to necessarily wait for certification for Nassau or Suffolk. We can just go ahead and say, to be careful and to be safe, because based on the information that we have right now, the unofficial results are showing that this is a close race, so we're going to do it. We're taking the position that all possible certifications have to be completed before we do the remainder of our process. It's not the case. So, based on the information that we have while we're doing our recanvassing, if it falls within that percentage, we'll manual recanvass, even if it's just being super duper cautious.
Yes, of course.
I just, my thing is that I don't think the language has to be changed. All we have to have is our interpretation on the bottom, just a little like, this is what this means.
I
Instead of
wouldn't
changing
change
the
the
whole
language,
thing.
but I would suggest putting an explanation.
Right, a footnote. I mean,
In the
revise.
procedures, rather than having to refer to board minutes every time we want to.
Right, no, it should say a footnote right in the bottom and say revised,
Right, where in
2014. This is the clarification of this word.
Right.
Simple.
Where the contest goes outside the New York City Board of Election, county lines. It's the entire contest that determines whether a member.
Right,
fine.
that's
All
my
right, so-
motion.
All right, there's a motion to adopt the canvassing procedures or the revisions and including a footnote explaining what that definition means. No, we're adopting everything, everything.
You want it, that's what I'm saying, you
No,
want
we're
a
adding-
clarification
Adding the
In a
clarification.
footnote.
or an extra sentence.
Right.
And the interpretation of what we. Correct.
All we have to do is.
No, I always see
parentheses,
footnotes.
The margin of victory is the entire, relates to the entire, district.
Give me the original, give me the original, right on the nose.
Right.
Is there a second?
Second.
All in favor? Yes. Absolutely.
Yes, John, you want to say something
So,
first?
yeah, if I could have just a clarification then, because this was actually broken into 3 parts, one about the manual canvas for public office only. Is that being adopted or not being adopted?
No, judicial delegates only.
Judicial
Judicial
delegates.
delegates only. Then the one about the reduce, if the total votes cast is over 1 million, it goes to 0.2% instead of a half, is that being
We
adopted or
really
not?
didn't discuss that a whole lot yet. So it's, on 1 million, it's 20,000 versus 50,000, right?
Correct.
And it's 3 million, it's 60,000 versus 150,000.
I will say that there was consensus amongst the staff on that, if that makes sense.
But what my numbers were just now?
No,
or
no,
my
no.
policy?
No, on the reducing of over 1 million to 0.2%. We did have consensus on that.
So what is that, there's 1 million votes cast?
Right, we would reduce it from 0.5% to 0.2%. Basically, as we're improving with the processing of the electronic data, you know, and now that we've had 4 years worth of, you know, pretty good reliance on that, and we haven't had this situation, we thought that this was a good time to take a look at that and move that number down a little bit so
Is
that,
there a state board guideline on this?
no.
They don't do manual
We're
canvas.
the only board in the state, as you know, with editorial approval, that has this policy. Everybody else runs to court and waits for the court to direct something.
Of note, in the Fiddler-Strobin manual recount of 22,000 votes, I believe the margin of victory went from 27 to either 11 or 13, and that was easily explainable by, again, failing to mark the circle, circling a name, putting an X. So the disparity between the scanner count and the hand count was explained in the standards used to determine the intent of the voter instead of just looking at the circle. So I think that supports the idea that this modification should and can be made at this time.
Small?
Have we ever had a situation in which the total number of votes in the New York City portion could not have affected the outcome regardless? So in other words, if we had the hypothetical situation where if you have...
Yeah, we
We
moved on.
we moved on from that, we're on to another.
No,
one.
I'll say something else.
I guess like the congressional seat that.
No. In this cross county, have we ever had the situation where, let's just say, I'm throwing out numbers, you have 30,000 votes, you have 500 votes in, or 1,000 votes in New York County, and if you recapped it and all the votes went one way and you switched it, it wouldn't make a difference.
We haven't had a situation. The fact is, all of the close contests have been so far wholly within the city of New York, either in the form of state senator, assembly, Democratic state committee members in 2 counties, Brooklyn and Queens. What?
Delegate alternates in Manhattan.
Delegates all listed in Manhattan.
District leader.
And district leader in Queens.
So, the 1 million, the 1 million, this was put in when we first got citywide?
No, we had no
When we
distinction.
first got the first machines, these new machines?
2001, when we went to automated scannable absentee ballots.
That's when these
The
rules were.
commissioners initially adopted the campus procedures, to set a guidance as to what we're going to do, and again, to adopt it in advance of the election, so that there would be no question of what the guidance would be to the staff, and also in terms of defending ourselves in response to people against Iran too.
Well, it's not a mathematical, it's
a judgment.
It's really just a judgment call at that point. You know, whether or not the results, you know, when we
The
still,
larger number.
you know, whether or not the results could be changed.
Given the larger
You know, because
number.
given a larger number, the aggregates go up too. When you have when you have the same percentage, but of a larger pool, the the distance between, you know, the voters is actually increases over the, you know.
Isn't it based on percentage of a margin of victory?
Right, but the point is, if it's a 10-vote contest, and you're going with, you know, 20% is two votes, 20% of 10, right? As opposed to 20% of 1,000,000, which is 200,000 votes. I mean, so the idea was to create a line of demarcation, and where we went with the 1,000 was rather than say in city, the 1,000,000, rather than say it's citywide contests only, we picked the 1,000,000 because it effectively makes it a citywide contest, but it also could affect, you know, gubernatorial, presidential, whatever. So we thought that going with the word citywide contest would have a specific connotation, i.e., you know, comptroller, mayor, you know, or public advocate, as opposed to saying just over 1,000,000, which we know that are those three elections, pretty much the mayor, the governor, and the president usually get 1,000,000 votes or more. Total votes canceled.
I think it's okay because of the larger numbers involved.
Right,
So by percentages, it's almost the same thing if you go.
You know, when you get into the smaller subdivisions and you start going by percentages, the numbers are closer, the numbers really matter. Whereas once you get, you know, over 1,000,000 votes, now you're talking about still a large number of votes that somebody would have to make.
So that was the rationale the commissioners adopted, so the 10-vote number as well as the percentage, because if you're dealing with a
With a
very
small
small
number,
race,
right.
and it is a 3-vote difference, it may actually be, if there's only 10 votes cast, that's 30%, you don't count it, but with 3 votes difference, it may
It's the
change.
same thing as when you do percentages, when you pass it, how many kids test, and how many, 5 kids passed or 35% passed, you know, same thing.
All right, so the motion's been made, it's been seconded.
Any clarification you need?
Just lastly, then, I guess, on the last one, we're gonna take out the change, and add the words wholly within the city of New York, and then put a footnote saying that basically means the entire contest, not just
No,
the
John,
one.
what we're gonna do is we're gonna leave the wording exactly the way it is in the current policy and just make a clarification to say
Then that's what-
that the margin of victory pertains to the entire district.
Right, the wording in the original doesn't have anything about the alternates or about the 0.2% for the over 1,000,000 votes. So that's what I'm saying.
That was your changing.
That's what, so we're changing, that's what the clarification, we're changing the first one to say, right now we have it saying no, only for public offices, we're gonna change it to say that it's only for offices other than delegate and alternate. In the second case, we're gonna leave that as it is, that's gonna be 0.2% for over 1,000,000 votes. And then the last one where we had to say wholly within the city of New York, we're gonna strike the wholly, and
put
we're
it
gonna
back
put
in.
we'll put it back to what it said, which was just margin of victory, with a footnote saying that it means the entire contest, not just the part of the city.
Got it.
Correct.
And I'm assuming then, or lastly then, as far as these changes are concerned, we're gonna submit that then, of course, to legal for their review, and then is it gonna be executive management, the yay and nay to get this out to the people?
We're
or is it
doing
gotta
it
go
now,
to-
so
This is it.
This
In
is
other
it.
words, theoretically, legal and executive management have approved this before it got to us.
Right,
So
I'm
this
just gonna,
is
who's
it.
gonna approve the rewrite before I send it to the boroughs, is all I'm asking.
me, unless there's an objection from the commissioners.
And 15 minutes it should take.
It shouldn't take long, I just wanna make sure that I don't have to wait
So
till
before we leave.
the next
No,
meeting, which
no.
would be after the election.
No,
So it's executive management is gonna then approve the rewrite, get it out to the boroughs.
and this is in effect for
Right.
immediately.
That's the intention.
Right, and the other thing I did want to, on that issue of when things are going into effect, the electronic writing filter, I had instructed Mr. Nordis to preliminarily schedule the training for the folks that will be doing this review for the 10th of September to make sure that, well, when they're doing their process, it's not an extensive training, it's just a familiarization with how it works. So we had that tentatively scheduled, subject to approval of that change. And now that we've got that approval, they'll be using that process for the primary.
Except for we have to-
Yes. So we
I'm sorry,
first want a
once-
second, and
right,
then
I'm
vote.
sorry, but once
don't
we
have
have-
6 votes yet.
When we get the approval, we'll do that training.
Yes.
Two things. The Manhattan chief and deputy, at the last time they had to do it, recommended also add, which is not included, the idea that the voter history comparison be done so we can prevent the recertifications before we do certification. And secondly, you recommended, but was not included in the draft submitted to you, was the idea of review and audit to make sure that the valid accountability reports are correct, because given the way we changed the return to canvas now, if there's gonna be a closed contest, that's gonna be subject to court review. And if we haven't done it, it's gonna look embarrassing to us that the inspectors having to account for where the ballots are in a closed contest.
Well, I guess have those suggestions made to executive management, have you guys review it.
Voter history is.
Mhm. Okay?
But I will say, it's exactly this kind of stuff.
Changed, it was 2012.
It's exactly this kind of stuff that takes us so long to get things done. Because it went back and forth and back and forth and back and forth between the two units. We finally get it in front of the commissioners, and now again, at 10 to 3, after we've discussed this.
Voter history is done.
Wait.
That's not the point I'm making. The point I'm making is, it's 10 to 3 on a Thursday. These procedures have been going back and forth, and yet we're getting another potential addition to changes.
It was included in the recommendations we gave, it just wasn't included in the final draft.
Okay, well, it's not here, so it's not before us.
Correct.
So let's get this one done and then move on to the next one.
All right, so the motion's been made, it's been seconded, all in favor? Anybody opposed or abstained? All right, the motion carries.
Thank you, Commissioners.
All right, Ms. LaBelle?
All right. You hide on us?
Good afternoon, Commissioners. We submitted for your approval for worker exceptions for the state primary on September 9th. Manhattan has requested 15 Spanish interpreters in poll sites where they feel they need relief interpreters. Queens has requested 8 coordinators in high-traffic poll sites. Staten Island has requested 11 coordinators and 6 door clerks in high-traffic poll sites. Bronx and Brooklyn asked for nothing. So we seek your approval.
I move we approve these exceptions.
Is there a second? All in favor? Anybody opposed or abstained? All right, the motion carries. All right, Mr. Richards, you want to call the gentleman?
Gentlemen, you have your challenge for the registration.
Just wait. No, Mr. Flash, I am aware that you're here. We're going to take care of you right after these gentlemen.
Good afternoon, Commissioners.
Good afternoon. Can you please just state your name for the record?
Allington Brown, 1059 Belmont Avenue, Brooklyn, New York.
Rita Figaro, the Figaro Law Office.
Commissioners, we're here to object on a challenge of a registration of a voter. And we're challenging that based on the fact that we examined some records at the Board of Election, and upon that examination, we found that the voter, Rodney Burchett, moved into New York State from 746 Sapphire Drive in Bolingbrook, Illinois, zip code 60490, and failed to submit a new registration form as required by New York State law.
And did you provide a copy of the documentation to our council?
Yes, I did. We did it previously.
Do you have an affidavit of challenging the registration to be submitted to the commissioners? Do you have to swear to that? Challenge law. Ask him to give him the oath, if you would, and then therefore you will next witness time after. That's the challenge. That's the challenge after he takes the oath.
Can I just have you raise your right hand? Do you solemnly swear or affirm that the foregoing statement made by you on September 4th, 2014 is truthful, a truthful disclosure of the reasons for your belief that the registered voter therein named is not qualified to continue to be registered in the election district in which he or she is now registered?
I do, Mr. President.
Mr. President, under 5-220, upon the taking of the oath, with the board stand is supposed to review that matter. We actually have a report to you because this actual allegation was the subject of a court proceeding, which the executive committee authorized us to defend this morning. And I wanted to provide with you both copies of the relevant documentation for your consideration.
Have you had an opportunity to review the evidence?
Yes, Commissioners, we did, in preparation for the court proceeding. What is submitted is that in a registration form received by the board in 2007, the voter involved inadvertently checked the box address change on the top of a voter registration form and not new registration. However, if you will look at the board's activity report, which is the 4th page of the packet I gave you, on October 15th and 7th, we treated it as a new voter, and there was no confusion on the part of the board. The same allegations were made in court today, and I've also provided you a copy of the decision by Justice Smith in King Supreme, says that, it says, number 3, upon moving from Illinois to New York, Rodney Spachette became a qualified registered voter when her voter registration was filed on September 25th, 2007. Quote, it makes no difference whether she checked the box for new registration or the box for change of address. So, Commissioners, there's really no real investigation for the board to do. The evidence in our own records, which you have there, is that she filed a registration form clocked in by the board on September 25th, I believe, 2007, processed by the board following bipartisan review, added to the active voter rolls on October 15th of 2007, and subsequently there have been address changes, etc. But this is a ministerial or scrivener's error, if we could take a court case involving there, which both the court found and neither does the statute. The statute requires that the voter registration application contain all the required information, name, address, date of birth of the voter involved, along with their signature taking the oath. That form, which is the last page of your packet, has all of those information, including providing the last 4 digits, which was then matched on the Social Security number, so there was compliance with the HAVA requirements as this was received by mail. So accordingly, Commissioners, it's the recommendation of myself and the Deputy General Counsel, since we've been reviewing this over the last 2 days, that the challenge, although properly made now, should be rejected, that Ms. Bichette is properly registered, remains properly registered.
Would you like to add something?
Yes, I'd like counsel to answer that.
Good afternoon. I would like to have your attention to section 5208A of New York State elections law. And I'm going to quote directly from it. It relates,
we know.
Yeah, that section relates specifically to when a voter who is moving into the state of New York from a different jurisdiction submits a change of address form. Essentially, it's the same form that they fill out for a new registration, change of enrollment, but they check change of address. When that happened, the legislature thought about it and codified section 5208A, and it reads the following. If the Board of Elections receives notice of a change of address within such city or county from or with respect to a person who it determines is not registered in such a county or city, it shall forthwith send such person a notice to that affecting a form approved by the board, by the State Board of Elections, at the new address set forth in such notice of change of address, together with a voter registration form. Now, I ask for your attention to this section specifically because the legislature intended to have the board follow a certain procedure in circumstances where a change of address form is received by mail, such as this case. It did not empower the board to just go ahead and decide the intent of the voter for the voter. We are all for enfranchisement. We want people to register to vote, but we're just asking that the procedures be followed.
Commissioners, counsel makes a reference to the wrong section of the statute. He talks about a change of transfer of enrollment or registration for any pre-existing voter, and that's what 5208 is. It follows the sections relating to initially local registration. The statute was put together first with local registration, then if you transferred it after you've been registered. 5210 talks about registration and enrollment upon application. 5210 sets forth the procedures now, including the HAVA compliance, checking the information done. We acted properly with respect to this application with respect to 5210. 5-208 does not is not relevant to the first application that was submitted in 2007. This argument was made this morning before Justice Schmidt, and as you know from the thing, after all argument, it's been rejected. The correct language is in 5-210. The board staff, I should say, acted properly. Upon receipt of the application, they reviewed the board system. This voter was never registered, so they treated it as a new registration for a new application. They ran it through with the social security number through the statewide voter registration system, got confirmation that it matched, and therefore they properly registered her on October 15th, well within the 21 days to review the application upon submission. And accordingly, she was registered as of October 15, 2007. She has voted every subsequent year in every election. She has provided the board with notice through change of address forms on the registration form when she's moved, even though by state law she can only even go vote and change it through affidavit. So the citing to 5208 is no relevance to the initial processing of the 2007 application because there was nothing to transfer. Since she was never registered in the state of New York, she admits on the form that she was registered at an address outside the state.
So, long, short version is, she was in another state, she came over here, registered as a new registered, right?
She checked the wrong box. It checked the wrong box, but she used the appropriate form, provided all the required information.
What's the box you want?
She checked,
Change of address.
change of address.
Change of
But she
address.
was a change of address from
But
Illinois.
from Illinois,
She should have checked new registration.
Oh, she should have checked new registration because the law states that if you change from here, that's from one county.
One state to one state.
From one county to another in New York.
Right, but the statute provides that if the staff is satisfied with substantial compliance, they should register her.
Right.
Yes,
Yeah, I would move that we dismiss this procedure, challenge, based in part on the court order and the information provided to
Is
us.
there a second?
Can I,
All in favor? Anybody opposed or abstained? Motion carries. Okay.
thanks a lot.
Mr. Flax?
Before we begin, I'd like to mention to the honorable and learned commissioners that last year, 2013, in New York County, the Democratic Party's first judicial district designating convention for Supreme Court justice had delegates voting who were not elected. The official recount showed that some voted who were not delegates, and some were elected delegates didn't vote because of this. And in that contest, in the first district, there was no, hardly any paper ballots, or some affidavit A ballots. And I'd only like, as far as the executive director's remark that we should go back a century and count everything by hand, I think it's an excellent idea under the current system because your job is to give as much patronage, employment to the party faithful. So I think it would be good to expand the budget by $1 million for additional workers. And remember, Mr. Andino should remember that a predecessor, the convicted felon and former mafioso, former Commissioner Villela, said something very nice a long time ago, and only Mr. Humane was present in the small room upstairs. Referring to the cost, and I commend Villela for saying this, quote, "This is the price of democracy," end quote, and he meant it. Now, as to the matter at hand, what I'd like to bring up, since you're changing things for the primary, there is something you could do now, and that's the issue of how many scanner tapes should be printed out from each scanner. I submit, and the Commission of the State Board of Elections says it's correct, that 3 are required. And I believe Honorable Learned Counsel Stephen Howard Richmond also spoke up in favor of this, or part of it, at a previous meeting. that you need one tape to be the public tape. Forget, you can call it the wall tape, but you can sit on the floor, you can pass it around a table in the corner, however you wish. Then that public tape of the results should be available for as long as the poll site is open. You need a second one to go with, stapled to the tally sheet that goes in the return envelope. And you need a third one to go with the USB flash drive, which you call the portable memory device, but it's the universal serial bus drive or flash drive. As I said, you call it the PMD. That's taken over to the 77 police precincts in the city for transmittal electronically to headquarters and to the press pool run by the Associated Press. It doesn't take but additional minutes per machine, scanner, to print out this third tape. And the reluctance for your doing this amazes me. I have not spoken to 3,500 people. I've not spoken to 350 people, but I have spoken over the weeks to about 36 party people, party officials, position officials, and we laugh at it. And I raised it and said, something's wrong here. These commissioners just can't get their act together, and as Mr. Ryan said earlier, this is the type of stuff that takes so long to get things done. You just can't say, oh, we'll print out another one and put it in our operations manual for the election. It doesn't cost anything. There's plenty of tape in the machines. Every time you have an election, you have a brand new tape there full. And unlike the paper roll for write-ins on the shoot machines, which often stay there a decade or more.
Mr. Flex, allow Mr. Ryan to respond to that.
Well, I have one more thing to sum up here, sir, if I may. The flash drives that are sent to the police precinct, and I think now the cops have to sign a receipt with the time they received them, and that is left to the coordinator of the site. Is that so, Mr. Ryan? The receipt, the police have to sign that they got a flash drive to take to the precinct.
They signed, that's not new.
No, but they put the time they got on it.
That's not new.
All right, so it's there. So it would be interesting, I think, to see what time they signed for it and how long it took them to get it to the precinct. The argument was raised by someone saying that, oh, those are unofficial. They're no more unofficial than anything else you have, because the official results are those results you certify to the State Board of Elections. And it's no more official or unofficial than anything else. In fact, they're more nearly accurate, you could say that, and it's not all unofficial. So also, the tallies of any sort that you have are unofficial until you literally rubber stamp the certification to send to Albany. Again, to reiterate, those flash drives to the precincts they sent to the board and AP are more near.
These procedures were initially passed some months ago. So readdressing them now would be essentially undoing a previous commission decision. So I'd like to also make a clarification that executive management, and most notably myself, made the recommendation to the commissioners. So I think Mr. Flax, laying that issue at the feet of the commissioners is somewhat unfair, since they rely on me and my staff to investigate these matters and make a determination. I disagree with your assertion that a wall tape is required to be printed as a separate tape. The plan, as it stands now, is to print the tape, post it on the wall, allow the public to view it. The poll workers can then do their ballot accountability, which is separate and apart from having to do with anything with the tape. And at the end of it, the tape will be removed and attached to the return of canvas. So it's not a question of not having the public tape. It's a question of how many tapes do we ultimately have to print. And I think that's a good place to stop right there. I think that the procedures as presently adopted by the commissioners satisfy the law and meet the needs of the public as well. And that's where I stand on it. I don't know if anybody else wants to add anything to that, but that's where I stand on it. And we will certainly do satisfy our need to, our requirements to get the information out to the public on election night. No one's going to be excluded from reviewing those results. They haven't been in the past. I mean, I've closed poll sites myself years ago. And, you know, you always get, it's a little bit of frenetic activity there at the end of the night, but everybody gets what they need, and they walk out, and we can process these votes more quickly. Is legal and will meet the needs of all concerned.
Thank you, Mr. President. May I quickly respond?
No,
There's nothing to respond to.
Yes, there is something to
No,
say.
no, it's not a debate. We give you a response.
Well, I think you're
We
wrong.
know what happened. I know. We know you think you're wrong.
It's the election law that requires the public tape. And you talk about a cycle, when you get to many candidates on the ballot, that will not be in small offices, it won't be reported to CNN. There may be a lot of poll watchers who want to look at it, and we don't want to have that tape taken away from them.
All right, is there a motion to move into executive session?
So moved.
Second.
Personnel.
In executive session, the commissioners unanimously approved that Valerie Vasquez, Director of Communications, was granted 420 hours of advance time to be paid back with her accruals upon her return. The commencement date for this leave will be the first day of her absence due to childbirth. In addition, the commissioners unanimously approved that John Bojangles has been suspended without pay pending a disciplinary hearing to be held forthwith. And we're going to be recalling the CRU prima facie calendar. All right, a request is being made by Commissioner Humane that we adjourn or postpone the CRU prima facie calendar for 2 weeks from today, from Tuesday.
September 16th. In order for the candidate to come, they claim never to have gotten notice of the hearing. I understand, they claim never to have gotten notice, and they think that they did file something. So, wanted to give them an opportunity to come in and make their proof. Yes.
Is that seconded?
Second.
All in favor? Anybody opposed or abstaining? The motion carries. All right, now we'll move to adjourn the meeting.
Sure.
Second. All in favor? Anybody opposed or abstaining? Motion carries.
The initial problem here is that they forgot.
Are you ready?
Yes, according.
This is a meeting of the Commissioners Cover Sheet Review Committee to review a purported cure to a defect to an independent nominating petition cover sheet for Anthony Alderossi for member of the State Senate in the 12th Senate District. Commissioners, you made the determination a week ago Tuesday that the cover sheet lacked the name of the party, and the attempt to cure was attempted timely last week on August 29th at 3:05 p.m. They made the first attempt to cure following an amended cover sheet attached to the original defective cover sheet copy of, but did not include the required authorization. 3 minutes later, at 3:08, they then filed the amended cover sheet with the authorization. However, they didn't attach it to the copy of the original cover sheet defect. And then, for some reason, 2 minutes later, they filed a blank.
It would seem to me that this was a filing done as part of a continuation of process, and that we ought to allow this with the signature to be viewed the same as this one that contained the copy, so that we would be able to thank you.
And I will, you can see that they really, really tried. And this is official. It's stamped by the board, so I think it's good.
With addition, one day, the next, the cover sheet review committee meeting.